judges of the Kerala High Court. I see a judge from Andhra Pradesh and Telangana High Court. Learned Advocate General, my advocate friends and my dear students. Good morning. At the outset, I should tell you about the appreciation I have to the association for having this continuing legal education program. Roscoe Pound, a great legal philosopher, said that the hallmarks of a legal profession are organization, learning for the public good. This is important. The last one is very important. But to have learning for the purpose of doing some public good, we should justify that we are professionals. For which purpose we should continue to learn. There's no end to learning. As the learned Chief Justice was saying that if you think that out of college we don't need to open books, then you shouldn't get into this profession at all. This is a lifetime of reading and lifetime of learning. But I should tell you, with my experience of being a member of the bar for about 30 years, there's no profession more thrilling than this profession. I enjoyed my professional activity so thoroughly. I never felt that I was in a wrong place. And this is the only thing that I can do in my life. And I'm sure that most of the lawyers who are here would share my feelings. A word of advice for the law students, that you should not stop learning. And this learning should definitely be used for doing some public good to the service of the society and to the service of the nation. I also appreciate the association for the help rendered to the people of Kerala in times of need in the recent floods. I've heard so much about the active role played by the High Court Advocates Association in collecting huge funds and then distributing it to the needy people. I really appreciate the effort. It's not only the work that you do in court, but it's the direct assistance to the society when needed that plays a very important role in an individual being recognized as one who is conscious to the society's needs. Coming back to this topic, when I was asked to speak in the continuing legal education program, the offer given to me was to select a topic of my choice. When I think of Kerala, I should say that people in Kerala and the lawyers especially have been so affectionate to me. I argued my first case as a senior counsel here, though I went to Guwahati to argue a matter even before I was a senior counsel. Chief Justice Balakrishnan was inquiring, after seeing me argue in his court, who is this person from Kerala who is regularly appearing before me whom I never know? I haven't seen him in Kerala. He asked me once, where do you come from? I said, I come from Andhra Pradesh. He said, how are you arguing so many matters from Kerala? It's a love and affection of lawyers that gave me opportunities to appear in so many matters from Kerala. When I was coming here, like a normal human being, you think about your acquaintances, friends, that you're going to that place. Last year, we had a deliberation about separation of powers in the National Judicial Academy at Bhopal. Justice Jaishankar Nambiar was there. After I spoke for about half an hour, the High Court judges who were there for training were asked to participate in the discussion. One aspect raised by Justice Nambiar was on this due process. Without mincing words, he asked a straight question as to whether the judiciary in India has overstepped its limits by adopting the due process of law, which was specifically excluded from the Constitution. And is there a need for review even of Keshavananda Bharati? If I remember right, that was the question that he asked. So this is a debate which has been going on for a long time. So I thought of this topic of due process, which would be of interest to lawyers as well as law students. And this being a very controversial topic, I thought it might also generate some enthusiasm in people to think about how administration of justice is done in this country. So many questions arise. Due process is something which you don't find anywhere in the Constitution. And where has this due process come from? Why is it so controversial? Why is it that there is so much criticism about application of this principle of due process in this country? These are questions which I would be dealing with as I proceed to speak on this due process. After a long struggle for independence, the process of making a constitution started in 1947. There was an assembly of more than 100 people who have been selected. And there were some experts under the guidance of Dr. B.N. Ambedkar, who came from the Columbia University in States, who knew about this due process and how the democracy in US was working. Mr. B.N. Rao was given this task of going ahead with the Constitution. There were people who were asked to visit other countries to see how democracies in other countries were working. Dr. B.N. Rao visited England, Ireland, which was called Ayr then, Canada, and the United States of America. As we attained freedom, along with freedom, liberties, and the other rights that come from a well-functioning democracy, the idea was to find out how individuals' rights can be protected and how administration in the country also can smoothly run. So in his quest of finding out how smooth democracies run, Dr. Rao reached the United States of America. Then he met Justice Frankfurter. And Justice Frankfurter discussed with him about due process of law being included in the Constitution. What is this due process of law and where do you find it in the American Constitution? The Fifth Amendment, which is a part of Bill of Rights of the United States of America's Constitution, speaks of no life, liberty, or property being taken away without due process of law. The Fifth Amendment applies to the federal government, that is the Congress. And it took about 50, 60 years for an amendment to be made which applies to the states, and that's the 14th Amendment, which was made in 1860s, where the due process was made applicable to the states also, along with equal protection of laws. It will be amazing to know that there is no prohibition against the Congress from making any laws which provide equal protection of laws. It's not there in the US Constitution. It's only against the states. Equal protection of laws is there in 14th Amendment. There are privileges and immunities which are protected in the 14th Amendment of the Constitution, as well as what I just told you about deprivation of life, liberty, and property not being taken without the due process of law. One of the first cases where due process of law was applied in the United States of America was the dreadful Dred Scott's case. There was a legislation made recognizing the equality of African-born blacks in the United States of America. And in 1858, the same time when the mutiny started in this country, the United States of America Supreme Court struck it down. They said that the blacks cannot be considered to be equals, and applied the principle of the substantive due process of law, of looking into the contents of law for the purpose of declaring it to be bad in law. And that was a case which came to be reversed at a later point of time in 1960s. We need not go into that aspect, but this was the first case where the due process of law was applied. What is this due process of law and substantive due process of law which is which was applied in the United States? I'll just mention about 3 or 4 cases how the law developed in the US. Substantive due process of law. Due process of law is that the government, while making laws which affect the rights of individuals, have to justify that they have followed the procedure to make law, and they have also provided for the procedure which has to be followed in accordance with law. That's the principle. And what is the substantive due process? Substantive due process is any legislation or a statute cannot be law. It has to pass the muster of the test being reasonable, fair, for which purpose you look into the content of the law, the substance of the law, to review whether the rights of individuals are being affected in a particular manner, and that's how the principle of substantive due process of law is applied. Critics in United States of America, starting from Professor Ely, Richard Bach, who couldn't reach the Supreme Court, Justice Scalia, who recently died, and a host of others do not appreciate this principle of substantive due process of law. For them, the very phrase substantive due process of law is an oxymoron. An oxymoron is a self-contradiction. It's like I say that red pastel greenness. When you speak of substantive due process of law, substantive is different from process. That's how it is said by critics that it's an oxymoron. So the very phrase itself is criticized, saying that this is something which cannot be followed at all by courts where a few people sit who do not have the mandate of the public. They are not elected. They are also termed as counter-majoritarian. They are persons who cannot sit in judgment over what has been said in public benefit by the Parliament or the Congress. And they cannot substitute their wisdom to whatever was decided by the Parliament. So that's the criticism that comes with it. How did it develop in United States? There is a very interesting history to this. I'll not take you before Lochner. There is a case which was decided in 1910 by the United States of America Supreme Court called Lochner versus US. There was a law that was made by the government by which there was a restriction that people working in a bakery cannot work for more than 10 hours a day. That was challenged by the bakery owners by saying that it violates their right to enter into contracts, which according to them forms part of liberty that is protected by the Constitution. And they said that if my liberty is being taken away, this is violative of the due process of law. There was a judgment in favor of the bakery owners, saying that violation of a contract would amount to impingement of liberty of an individual, and due process would apply in cases, and the legislation was struck down. This falls under economic legislations because it deals with contracts. Starting from Lochner onwards, there were about 200 cases where the US Supreme Court has struck down legislations on economic principles till 1930s. In 1933, President Roosevelt came to power, and President Roosevelt announced that there would be a New Deal legislation. That is after the Great Depression in USA, where they suffered a lot because of economic distress. He said that we are going to bring in some legislations in public welfare. It's called the Great New Deal legislation. He brought out about 13 statutes to help people in terms of certain social welfare measures to be taken by the government. And the Supreme Court again applied the substantive due process principle to strike down those legislations. Roosevelt came back to power in 1936. Then he said that this can't happen. The US Supreme Court can't keep interfering in legislations that are made in public welfare, and their job is not to do that. He announced a plan that he'll increase the number of judges in the US Supreme Court from 9 to 15. So he'll pack more judges of his choice. And then the interference by the courts, Supreme Court, in matters of social welfare legislation by applying this principle of substantive due process stopped. There is a saying which says that switch in time, it's not stitch in time, switch in time saved 9. 9 are the number of judges in the US Supreme Court. So they switched in time to save themselves, and the US Supreme Court even today continues to have 9 Supreme Court judges. For a long period of time thereafter, interference on substantive due process principle in economic legislation stopped, and now there's absolutely no interference, I can say so surely, because like how we interpret statutes in this country, the US Supreme Court follows 3 principles when statutes are challenged in the Supreme Court. One is the strict scrutiny test. The strict scrutiny test is applied where the government has to justify, the burden is on the government to justify that there is an imminent danger or a compelling interest in public to deprive the public of their rights, which is quite difficult for the government to do it. There is another test which is called a rational test, where it is for the person who is going to court to prove that the rights that are deprived by legislation made by the parliament are so fundamental where interference should not be done by the government. Applying the rational test, it will be very difficult for an individual to get a judgment in his favor. There's a third principle which is called an intermediary principle. But on applying this rational principle now, economic legislations are not interfered with in the Supreme Court on this principle of substantive due process. I'll speak of the challenge to unenumerated principles in the Constitution, which are not mentioned in the Constitution, how court interferes at a later stage. But coming back to the framing of our Constitution, there was an advice given by Justice Frankfurter to B.N. Rao saying that this is not working well in this country because giving too much power to courts to interfere with legislations might not be the interests of the nation. B.N. Rao came back and there was a discussion in the Legislative Assembly. There were a few people who did not want to give power to the Supreme Court to keep interfering with legislations made by the Parliament. There were other people who were afraid that governments being run on party lines might bring in legislations which might not be in the interests of the people. And if you take away the power of the courts in interfering with those legislations, then it would be detrimental to the interests of the public. Dr. Ambedkar, making his speech after the discussion, he said that this is like a problem between Charybdis and Scylla. Charybdis and Scylla, for people who haven't heard, were two demons on both sides of the sea who were really troubling people who were traveling on the sea. You go to one end, their ships are wrecked. You go to the other end, Scylla keeps eating those people. So Dr. Ambedkar said, you have a problem. You give too much power to the parliament and then courts can't interfere, then you're stuck with legislations which might not be in the public welfare. And you give power to the courts to interfere in all legislations that are made by the government, then there might be too much of interference by a few people of legislations that might be made by the government. So he did not express his opinion and he left it to the assembly to decide. And ultimately, two things happened. One, the word personal was introduced before liberty in our constitution. Our constitution, Article 21 says, no person shall be deprived of his life and personal liberty without following the procedure established by law. These are the exact words used in Article 21. Property is out. Liberty is qualified by personal because liberty, the constitution makers did not want liberty to be widely worded so that it will include economic liberty, social liberty, all those things. So they said personal liberty of an individual. This is what is protected in the constitution. From this we can understand that there was a detailed discussion in the Constituent Assembly and these words, due process of law, were deleted from the constitution. There's a conscious decision taken that they would not form part of our constitution. After our Supreme Court started functioning, the first shot that was taken was in a case of A.K. Gopalan, where there was a matter pertaining to preventive detention which was argued before a constitution bench of the Supreme Court. There were lawyers who started arguing that the due process principle has to be applied to the Indian context, and the words that are used in our constitution, procedure established by law, are nothing but due process of law. He said that it connotes the same meaning. So you apply the principles and you also take into account the law that was there in US. And they said that the rights of an individual who was suffering from detention have to be considered in the light of the due process of law. The majority decided against that argument. They said that there was a conscious omission of due process of law, so the arguments on due process of law were not accepted by the Indian Supreme Court. And it was also stated in that judgment that fundamental rights are individual silos. You have Article 14, you have Article 19, 7 lamps of freedom, and you have Article 21, 22, etc. So everything is separate. Justice Fazal Ali, he was in the minority. He wrote a separate judgment. He said every act cannot be considered to be law. When you're speaking of law, procedure established by law. Law is the key word, and every law has to be a law which is just, which is also a fair law, which is also a reasonable law. So he said that he doesn't agree with the majority, but according to him, due process can be applied to judgments that are delivered by the Supreme Court also. But he was in the minority in Gopalan. There was a lot of development of law on various other provisions of the Constitution, like Article 14, Article 19, which I will just tell you now, and how they are connected to Article 21. You have closely heard me when I told you that Article 21 only deals with life and personal liberty and nothing else. And if you're talking of due process of law, it is to be applied only to those two aspects which are mentioned in Article 21. And due process is not available for testing any legislation on other fundamental rights. If any legislation is made by a statute, by a state, you can test the legislation as being violative of the fundamental rights, as being violative of any other provisions in the Constitution. And as lawyers and law students, you might have been informed that Article 14, which is an article which speaks about a right to equality and equal protection of laws, is the provision on which legislations are challenged normally in courts of law, in constitutional. There are various aspects of Article 14. One is classification, the other discrimination, and what we are concerned with for today's discussion is arbitrariness. Whether a legislation can be struck down on arbitrariness is again a principle of due process. In Royappa's case, Justice Bhagwati said that arbitrariness is an antithesis to equality, equality being something which is protected in the Constitution, which principle which we all are very happy that it is there, and which is very important for an egalitarian society and for everybody to be treated equally in this country. According to him, arbitrariness is antithesis to law, to start with. He read reasonableness, which is not mentioned in Article 14, from Article 19 into Article 14. The only place where you would find reasonableness in this trivetarium of these rights is only in Article 19. You have Article 19 where you are assured of your freedoms, freedom of speech, freedom of movement, freedom to form associations, to carry on a business of your choice, etc. And those freedoms are freedoms which are given to every individual in this country, which can be protected by an individual by challenging a legislation if that legislation is taking away their freedoms on the ground that it is an unreasonable restriction. This reasonableness from 19 has been imported into Article 14 in 1974 in Royappa's case. Said any classification that is made of dividing a group of people from the other group of people would result in an unreasonable classification which would make the statute unconstitutional. Unreasonableness became a part of equality, 14 and 19 being read together, and in Menaka Gandhi, Justice Bhagwati said that Article 14 is a part of Article 21, and any law that is made has to be procedurally perfect, which means that you can't just say that I'm making a law, procedure has to be followed. And that procedure to be followed should be fair, just, and reasonable. Reasonableness again comes into the article itself, Article 21. The difference between due process and substantive due process in US was also this. One is procedure should be there to be followed. That's the first principle for due process of law, where you are given an opportunity. Let us take the case of a trial. Whether a person can be punished without a trial. That is due process. And what do you mean by trial? Can you just say it's a trial and then don't follow the steps of a trial where a person is given an opportunity to cross-examine witnesses and thereafter make his submissions, get an opportunity of arguing before an independent tribunal. So all these are matters which are part of procedure itself, but also it's on the substance, where you are now trying to look into whether this has been followed properly. What was held in Menaka Gandhi, which is a landmark judgment in this country, is that fundamental rights cannot be seen to be independent silos, which means that if somebody comes and then challenges an act on the ground that it is violative of Article 21, it would not be sufficient for the government to say, now I have given an answer that Article 21 is not violated and that's the end of the story. It is a requirement that Article 14 and Article 19 also have to be satisfied. So it's not sufficient that one article is satisfied. The fundamental rights that are given to countrymen are a bunch of rights which inhere in every individual. And whenever there is a violation of a law and when that is tested, all these articles, all these rights also have to be tested and then held that they have not been violated. So in 1978, in Maneka Gandhi, the Supreme Court came to a conclusion that the procedural due process principle, procedure established by law, has to be followed. It's not just law, and it should be a law which is just, fair and reasonable, which is actually a departure from Gopalan's case, which I just mentioned. The majority there was, if there is a law, then we are not going to look into whether that law was properly made. That's beyond us, is what the court said then. And that the fundamental rights have to be seen as an amalgam came from the bank nationalization case, which is Coupa, which was followed in Maneka Gandhi. Thereafter, there were several cases that were decided by the Supreme Court of India. Some of them knew that there were constraints in importing this principle of due process of law from the American Constitution when it was specifically excluded by the constitution makers. There are some judgments which directly went into substantive due process of law. With due apology, Chief Justice Balakrishnan in Selvi's case, he starts off his judgments by saying that on the principle of substantive due process of law, an individual should get a right to prevent himself from intrusion into his body by being asked to undergo narco-analysis test, etc. There were other judgments pertaining to commercial law like Madia Chemicals, where the due process of law was applied. It is beyond me as to how a due process of law can be applied in economic legislation in this country because of the words personal liberty. There have been some judgments which have been delivered by the Supreme Court themselves, following the principles of due process of law and saying that procedure established by law is on par with the due process of law. Law is what is important, and the logic is when you're making law, not every act that is made by the legislature can be falling within the terms of this word law, and the procedure to be a procedure established by law would not only include the procedure to be followed by the legislature, but also the procedure that is prescribed in a particular law also. Justice Jeevan Reddy, in a judgment pertaining to potable liquor, McDowell's versus State of Andhra Pradesh, he delivered a judgment saying that procedure established by law is the language used in Article 21. Due process of law is not available in India, and arbitrariness cannot be a ground for striking down a legislation. He said that if a few judges sit in a court and substitute their wisdom for the wisdom of the parliament, that would be transgressing the limits of judicial review. If arbitrariness is a ground for interference with legislations, according to him, the courts would start playing the role of a legislature, which it is not supposed to do in this country, which is where we accept separation of powers principle. that held the field for some time. There was a discussion as to whether arbitrariness can be a ground for setting aside legislations. But it didn't stand for long. Justice Rohinton Nariman in a case called Muhammad Arif, where they were deciding the matter pertaining to reviews in Supreme Court being heard in open court. You must be knowing that the procedure of reviews in Supreme Court is that they're decided in the chambers. There is no hearing for review applications like you have in the high courts. In matters pertaining to death sentences, there was an argument saying that there is a requirement for a hearing in open court because this is a serious matter pertaining to taking away the life of somebody. Justice Nariman accepted that, and the case was allowed. A 30-minute time slot was given for a lawyer to argue in open court as to why the judgment of the Supreme Court affirming the death sentence is to be reviewed or is to be set aside. While saying so, he said that the substantive due process has taken a 360-degree circle. According to him, where we started and where we are now is completely different. He refers to various judgments, including Indira Gandhi, Nehru, etc., where the principle of due process, if not the due process principle itself, was followed by the courts in looking into the contents of the legislation and then declaring it to be arbitrary. He said that manifest arbitrariness can be a ground for interference with a statute made by the legislature. And he has given certain principles or guidance as to what manifest arbitrariness is and what are the factors that have to be taken into account for applicability of the principle of arbitrariness. Thereafter came two judgments to which I will refer now. One is Shaira Bano, which is the triple talaq judgment, where Justice Nariman again struck down the triple talaq legislation of 1937 as being arbitrary. The next judgment is Puttaswamy, the matter pertaining to privacy rights. And if you see the judgment of Dr. Chandrachud, he refers to the development of law on this principle of substantive due process and the due process principle as to how it was made applicable in this country as time passed from 1950s till now. He says that substantive due process itself might not be applicable in this country when it was categorically excluded in the Constitution after a debate. It's not as if there is silence in the Constitution here. It's not a dark matter, but it's a specifically excluded matter, and so it should not be applied. But then, at this stage, what is it that we can come up with insofar as this due process is concerned? Due process and the principles of due process, if you find in the procedure established by law, is something which pertains only to personal liberty and life, which you read along with personal liberty. Procedure established by law is the language used in the Japanese Constitution, which we borrowed from. And procedure established by law was included in the Japanese Constitution after the Second World War by some American scholars. With the help of American scholars, procedure established by law was included in the Japanese Constitution. So one theory is procedure established by law is nothing but due process of law. Coming back to where we are and what we are discussing, there is no restriction for interference of courts in legislations if they are violative of Article 14 or Article 19. When somebody comes to court challenging a legislation on the ground that his right to speech is infringed. Article 19 itself speaks of reasonable restrictions of all the rights that are there in Article 19. So if somebody is coming to court, the court has a duty to look into the law for the purpose of finding out that the restrictions are not reasonable. Justice Matthew, while speaking in the first Tegh Bahadur Memorial Lecture, he said that why is it people are speaking about this due process and making a big noise about it? Our constitution, forgetting about Article 21, gives power to the constitutional courts to look at the substance of a statute which is challenged. If it is violative of 19, it has to look into the statute for the purpose of finding out whether it's reasonable or not, the restriction that is placed. And if a statute is challenged as being violative of Article 14, after reasonableness has been read into equality and Article 14 for equal protection of laws, reasonableness is a principle which has to be seen if a statute is challenged as being violative of Article 14. So procedure established by law is not a mere procedure of the legislature having the powers and the procedure that is prescribed in the statute itself being fair, as has been read in Maneka Gandhi. But also if you're seeing that this is a law which is made, the law also has to be fair if it is being challenged on 14 and 19. But where does the rub lie then? If somebody can challenge a statute under 14 and succeed, or by the court looking into the statute for the purpose of saying that this is against constitutional principles, and looking into 19 for the purpose of the court saying that this is violative of the clause itself because the restrictions that are imposed are unreasonable. Let us say that there is a law made by the state of Kerala saying that no people should hold a public meeting for the next 1 year. So that's a restriction on the right of speech. And for the state of Kerala, Sudhakar Prasad will come and start arguing that this is a reasonable restriction in court. The court would have a duty to find out as to whether the restriction is reasonable, look into the statute, and then also look into the compelling public interest as to why this statute was made and what are the rights of individuals which are being canvassed before court for the purpose of finding out whether there is a restriction that is placed which can be said to be unreasonable. So for which purpose the court is having a duty to look into the substance of the statute itself. Then why are you unnecessarily having a problem with this principle of due process of law being applied to certain situations? The major problem that arises on applicability of due process of law, which I said is applicable only to life, which has been read to be very expansive in this country, and personal liberty. These are the two areas where the problem arises. There are certain unenumerated rights which are not found in the Constitution, the protection of which is subject matter of various disputes, several disputes that are raised by individuals. The cherished right of liberty of an individual. What is this liberty which we are speaking of? The liberty is a right of an individual to live as he likes, to do whatever he wants, to also improve himself as an individual. And this liberty being the hallmark of a democracy, this liberty has to be protected. Liberty has been the starting point for rights of privacy being canvassed in courts for the past 150, 200 years. When the substantive due process was debated in the USA, Cardozo and Frankfurter were speaking of a principle called ordered liberty. And according to them, liberty of an individual is important, but order of the society is also equally important. A person can assert his rights of liberty within the limits of whatever the society needs. They tried to balance this. Intrusion of a policeman into your house, protection of your property, these were rights of privacy which were initially spoken of. The Fourth Amendment of the US Constitution protects the property of an individual and his rights are protected there. Privacy is not mentioned again there. You can even go further, long back to the 1600s, where Lord Coke said that a man's hut is his castle and nobody can go and intrude into his house without his permission. People being searched in the night, seizures being made without a warrant, are subject matters of a number of cases in US. The very first case where Justice Brandeis wrote a dissent is Olmstead versus US, where there was an unreasonable search, material was taken without a warrant and a person was convicted on the basis of that. Matter went to the Supreme Court. It was decided that it's an unreasonable search and unconstitutional, so the material cannot be relied upon. Luckily, we don't follow that principle. We don't see there is a principle in US which is called fruits of a poisonous tree cannot be taken into account. Here, we don't have that principle. So the manner and method of search is not really important here. But we are now concerned today with these privacy rights. When privacy initially was being spoken of only in this manner, in 1967, privacy started taking a different turn in the United States of America. There was a law made in Connecticut by which doctors were prohibited from making prescriptions for purchase of contraceptives. And that was challenged in a judgment, in a very important judgment of Griswold versus Connecticut. It was decided that this intrudes into the privacy. You cannot permit a policeman to go into a bedroom and start searching for contraceptives. The importance of this judgment is dealing with the argument as to where are these rights coming from. There's nothing in the Constitution which speaks of privacy. Why is it that the Supreme Court is now trying to find out certain rights? Justice Douglas wrote this judgment in 1967 where he said that you can find these rights in the penumbras or the periphery of the Bill of Rights. The Bill of Rights protects the individuals in the United States of America, but somewhere in the periphery or the penumbras, these rights of privacy and the other rights are found, is what Justice Douglas said. 5 years later, a very important case which all of you would have heard, Roe versus Wade, pertaining to arbitrary abortions, was decided by the US Supreme Court. For the first time, they decided that a person has a right to abort. And thereafter, you have sodomy, which was originally an offense, with the challenge to sodomy being set aside. But again, in Lawrence in Texas, the court held that it is between two individuals. Gay marriages were recognized. So privacy rights insofar as reproduction, the manner in which they live, the way they want to rear children, their own personal rights, have been given a lot of importance by the US Supreme Court on this connotation you have liberty for. And the latest judgments pertaining to the use of mobile phones makes a very interesting reading. I would commend to all of you to read a judgment delivered by the US Supreme Court on June 28th of this year called Carpenter versus US. You all know, and even law students might have heard, that nowadays all investigations by the police are conducted on the basis of your mobile phones and computers. The moment a person is arrested, his mobile phone is taken. for the purpose of finding out where he was, with whom he was speaking. And these mobile phones can give the police so much of information about an individual for the past few months or years. Whether the seizure of mobile phones and using the information in these mobile phones is violative of the Constitution of USA was the subject matter of this Carpenter versus US. In a 5-4 judgment, 5 being the majority written by Chief Justice Roberts, they held that this is an intrusion into privacy of an individual, and without a warrant taken from the magistrate, you cannot seize these phones and use the information in the mobile phones. There's a principle called third-party principle, because you yourself have voluntarily given this information to the mobile phones. There's no point in stopping the government from using it. That principle was also not applied to this case, where the court held that you cannot do it. This is intrusion into the privacy. There's another case which is of this year, in May, Connolly versus US, where 2 youngsters, as we see youngsters here also, if you have good roads, they were ripping on the roads, driving at about 140 kilometers per hour on motorbikes. They reached home and the police chased them, and the police had to get into their driveway, go into their garage for the purpose of seizing these motorbikes. That was also held by the US Supreme Court, a judgment written by Justice Sonia Sotomayor. It's almost a unanimous judgment, where she said that this again is intrusion into a house to seize motorbikes without a warrant. So privacy rights are given paramount importance in the United States of America, the Constitution of which we are following for these fundamental rights of 21. And now in our country, all of you are aware of the recent judgments, the recent 2-3 months, or for the past 6 months. We had a number of judgments pertaining to Article 377, Section 497 IPC. I hope all of you are following what I'm saying instead of getting into losing time now. So, and the privacy case. These are very important cases which have dealt with the rights of privacy to individuals. But the point that for our discussion is, when this aspect is raised before court, as to whether the court is right in protecting the individual's privacy on certain aspects which are not mentioned in the Constitution, and what is the role of the court in adjudicating matters pertaining to liberty of an individual. There are 2 principles on the basis of which, though they're not mentioned in each judgment, these are 2 principles which are the basis for the court to uphold the rights which are not mentioned in the Constitution. Look at 21. You have personal liberty. How do you look at personal liberty? Personal liberty cannot be given a restricted meaning. And if liberty of an individual involves the rights of individuals, they have a right to seek protection from the courts of the right that is given to them under the Constitution. And if the rights are evolving, and if the rights are recognized in a society, balancing these rights with the needs of the society is an important function that is to be done by the courts. There is a theory which is now evolving, which is called a transformational constitutionalism theory. All of us want our society to be transferred. The fundamental rights that are given to each individual in this country to be implemented in their full spirit. And if you have to ensure that these fundamental rights are fully implemented, then the court has to balance these interests. Whether the court is going beyond its jurisdiction, I'm not sure that there would be too much of a criticism on this front. unenumerated rights doesn't, according to me, pose a very serious problem, as I just mentioned, importing the principles of due process of law for the purpose of adjudging cases pertaining to legislation that is brought before the court on grounds that are not permitted. What are these grounds that are not permitted? Let us see what the critics say. The critics say that the parliament knows what is best for the citizens of this country. They make legislations, and on the ground that 2 judges sitting in a high court or 3 judges, let us increase the number to 5 judges in cases, they sit and then they feel that this is not good for the society, and so say it is arbitrary and strike it down. Whether this is permissible under the Constitution, which recognizes the separation of powers, gives this power to the courts to do it. This is the question that has been there for a very long time. If you look at the important cases which have a bearing on societal interests, I don't want to enter into the controversy. Let us take the case of Sabarimala. I'm not going to go into it. You must have been seeing for the past 2 months about the views of both sides, mainly on the side of criticizing the judgment of intrusion into the religion. As and when a sensitive case is decided by the court, such problems would definitely crop up, and the question would be this: whether the court has exceeded its jurisdiction. One thing that has to be kept in mind by members of the legal profession, which includes the students also, is that the courts exist for the purpose of doing justice to the citizens of this country. And justice being delivered to the citizens of this country should be within the contours of the permissible limits of the Constitution itself, not transgressing the limits of the Constitution. Justifications being made by saying that liberty is very important for an individual, which needs to be protected, which enables the court to try to protect his fundamental rights, is sometimes criticized by saying that you don't have the business to do this. Who are you to decide this? Law that is administered in every country, for that matter of fact, is on the basis of the standards in which people are living in that society. It has to be only for the people of that society. I'm reminded of a case on religion, which I was recently referring to in another talk. There is a Hindu festival in Singapore, which is actually a festival which has gone from Palani. They have a festival called Thaipusam, the Tamil population, and mainly people who are immigrants in other countries, they celebrate this with fervor. And when they do this, they take out processions. You must have seen in a number of Malayalam films, people poking all this. When you show Tamilians, that's what you do. You show them only in this light, that they're poking all these words, etc. here. So they do this. And the Singapore government said that we're not going to permit all this. What is this nonsense? You're making a lot of sound and you're disturbing people. So this procession should not go on. And there was one Vijay Kumar who went to the court. He said, this is part of my religion. How do you interfere with this? It's an essential practice of my religion. And it's been going on for thousands of years. The court held in his favor. And he said, if it's a religious practice and if the religion believes that this is a religious practice, it's not for the government to interfere. But the important point which I want to make for this, not regarding religion, is that it is being stated by the Court of Appeal in Singapore that we are deciding this case only for the purpose of adjudicating rights of Hindus practicing this Thaipusam in Singapore. We're not concerned even with Hindus in India. We don't want to write a judgment as to whether this is really an essential practice in India or elsewhere in the world. And this is the correct practice to be followed. If at all law is being decided for the people of this country, like Sandra O'Connor said in one judgment, she said that These rights keep evolving. What was not a right of privacy in 1900s might be a very important right which an individual needs to protect now in 2018. So these are certain things which are taken into account by the court for the protection of individuals' rights. In conclusion, due process of law or substantive due process of law is not a part of our constitution. And according to me, Article 14 and Article 19 permitting a process where the statute is looked into for the purpose of adjudicating that it is constitutional or otherwise. Challenges to unenumerated rights in Article 21 also can be looked into on the words that are used in the Constitution, procedure established by law. Procedure is the procedure to be followed, which is fair, just, and reasonable, which again, substance comes in there, and law is not every statute that is made by the legislation. But this comes with a caveat. Jaishankar Nambiar might still ask me, what is in the name? A rose is a rose. So you just change the bottle and then you say that this is different, and the debate goes on. Thank you very much for the attention.